Thank you, Your Worship. The date is the 2nd of February 2023. Case numbers Regional Court 446 of 2020. The parties are the same as yesterday. Advocate Cedar appearing on behalf of the state. Advocate Holders on behalf of accused number 1. Advocate Lawrence on behalf of the accused number 2. The proceedings are mechanically recorded in the Regional Court 1. All the parties are ready to proceed, Your Worship.
Thank you. George, please. Advocate Holders, for the record, the defense ready to proceed with on behalf of accused 1.
Accused, I act for accused number 1, called my name is Lawrence Holders. I act for accused number 1, the representative of accused number 2 isn't Advocate Lawrence, it's Shane Matthews.
My apologies, Your Worship.
Advocate Matthews. Thank you. Thank you, Advocate Holders. You may proceed.
Thank you, Worship. Your Worship, as previously alluded to, we have compiled an application on behalf of accused number 1. And we've referred in the application to the first applicant. Your Worship, rather than duplicating matters, accused number 2 is referred to in the application as the second applicant, and he has signed a confirmatory affidavit, so we don't repeat everything and have a duplication. Worship, in this regard, we have a written application that's been signed and proposed to by the first applicant, and the confirmatory has been signed and proposed to by the second applicant, and duly signed by a Commission of Oaths. I beg leave to hand a signed original to Your Worship, and they signed the original from my learned friend as well.
Thank you.
Easy to follow.
It will indeed.
Your Worship, with Your Worship, the intention would be to launch the application, go through the factual vermins from our side, and thereafter by the second applicant, the state, and thereafter, once we've dealt with the factual vermins and the base of the application, address Your Worship on the law. So it's first the facts and then the law from my Your Worship. Thank you, Your Worship. It's headed in the Regional Division of the Eastern Cape, held at East London, case number 446/2020. The matter between Julius Malema, first applicant, Fair Harbors Arguments, name and second applicant, and Regional Magistrate Mrs. T. Udifir, respondent. Notice of motion, take notice that application will be made on behalf of the above-mentioned applicants. This Honourable Court on 2 February 2023 at 0900 hours. Also, soon thereafter, the matter will be heard for an order in the following terms. 1. Magistrate Mrs. T. Udifir recused herself from presiding as the magistrate in this matter. 2. Proceedings must commence de novo before another magistrate. 3. Further with alternative relief. We then also allude to the fact that the affidavit of the first applicant and the second applicant's statement will be annexed in support of the application. It's duly signed by both firms of attorneys, Your Worship, the combined application on the 2nd of February 2023. The two attorneys being Ian Levitt's attorneys and Carlett Crockett and Associates Inc. for the second applicant. Bishop, I apologize, Worship, for see there's a spelling mistake in the name of the first applicant. I accept responsibility and not very good at typing when we can take normal facilities available. It's then headed in the Regional Division of the Eastern Cape, held at East London, case number RC-46/2020, the same heading. And then we have the first applicant's founding affidavit, which reads as follows. I, the undersigned Julius Malema, do hereby make oath and state. The parties: 1. I am an adult male Commander-in-Chief of the Economic Freedom Fighters, the EFF. I am accused 1 in the criminal matter and the first applicant in this application. The facts contained herein are true and correct to the best of my knowledge and belief, and save where the context states the contrary, or within my personal knowledge. Where I make submissions on law, I do so in advice of my legal counsel. 2. The second applicant is Gerardus Adrian Snyman, an adult male businessman who is my co-accused and accused 2 in the criminal matter, as well as the second applicant in this application. 3. The respondent is the regional magistrate, Mrs. T. Urifia, who is currently the presiding officer in the criminal trial against the second applicant and me in the Regional Division of the Eastern Cape, held at East London. Background. 4. This application is premised upon the constitutionality recognized the right to a fair trial as embodied in Section 34 and 35 of the Constitution of the Republic of South Africa, Act 108 of 1996, hereinafter referred to as the Constitution. In particular, the second applicant and I specifically rely upon our right to justice and access to court as envisaged in Section 34 of the Constitution, which provides as follows. Access to courts. Everyone has the right to have any dispute that can be resolved by the application of law, decided in a fair public hearing before a court, or where appropriate, another independent and impartial tribunal or forum. 5. The charges against me relate to an incident that is alleged to have occurred in this Honourable Court's jurisdiction on 28 July 2018 when we were celebrating the EFF's 5th birthday. 6. The second applicant and I were summoned to appear before this Honourable Court on 27 November 2019. We did so and were subsequently released on warning. 7. Thereafter, there were several postponements until the matter eventually proceeded to trial before the respondent. I pleaded not guilty to the charges on 1 March 2022 and put the state to the proof of the allegations against me. Our right to do so is also recognized in Section 35 of the Constitution. 8. The second applicant also pleaded not guilty on that day, but submitted a detailed explanation of his plea in terms of Section 115 of the Criminal Procedure Act, 51 of 1977. 9. The state thereafter commenced by leading the evidence of 9 witnesses, the last of which was Colonel Magadleka. Once he had completed his evidence in chief, cross-examination and re-examination, the respondent reserved unto herself the right to question his witnesses to avoid having to call him in terms of Section 186 of the Criminal Procedure Act when the trial continued. 10. The matter then recommenced on 30 January 2023. That day, the respondent then asked if my co-accused counsel had completed his cross-examination of Colonel Magadleka. He confirmed that he had. The respondent then asked the prosecutor whether he had any re-examination. He then stated that he also completed his re-examination. The second applicant's counsel then advised the respondent that all questioning had been completed, but for the respondent's possible questions to clarify issues. The respondent then had regard to announce and stated that she did not have any questions for this witness and consequently excused him. 11. Thereafter, the prosecutor sought to introduce and play video evidence in court. This was opposed by the second applicants and my counsel, which in turn resulted in legal argument being presented concerning the admissibility of video evidence. 12. The respondent subsequently ruled that the video evidence was real evidence and could be played before her without the need for a trial within a trial. The prosecutor then commenced to present the evidence of what he referred to as the beer house witnesses with a view to playing the video evidence in court. 30. The first beer house witness was Mr. Sibusiso, Professor Nkobo, He presented evidence concerning 2 portions of video footage that had been in the possession of Gearhouse, but which he had not personally captured. He was then asked to look at a 3rd footage, the source of which was unknown. Once his evidence in chief had been completed, cross-examination took place and he was then re-examined. 40. Thereafter, the respondent requested the 3rd video footage to be shown to this witness, despite the fact that the witness had testified that this footage did not emanate from Gearhouse. She then asked him whether he had seen anybody that was familiar to him. He replied that he had and identified me. She then asked him whether there was anybody else, save for me, that he could identify on his footage. He then replied that there were other people that he did not know. She then again asked him whether anybody else had caught his attention. He replied in the negative. She then repeated the question asked, not at all. The witness confirmed that he could not identify anyone else. 50. Thereafter, the respondent asked all of the legal representatives whether they had any further questions. The prosecutor and my counsel had no questions, but the second applicant's counsel put to the witness that the 3rd video was not his company's video, and he could not even say whether it was from the day in question. He agreed with this contention. The respondent then commented that that had been established. 16. This question by the respondent cannot, in my respectful submission, be considered to have been required to clarify any particular point. The focus of the questioning undoubtedly was to get the witness to identify the second applicant and me on the 3rd video footage, the source of which was clearly unknown. 17. My submissions in this regard are fortified by that witness's previous responses to questions by the prosecutor when he asked the witness whether he knew the second applicant, and he had replied in the negative. He had also asked whether he had seen him on 28 July 2018, to which he answered in the affirmative. However, when asked where he had seen him, he had answered that he could not be precise as he was busy working. There can thus be no doubt that at the very least the perception created by the respondent's questions in this regard was that she was attempting to assist the prosecutor and not clarify anything. 18. The second Gearhouse witness was Mr. Ashley Singh, a branch manager. He had not even been present at the event on 28 July 2018. He had merely been requested by the investigating officer, Brigadier Governor, to hand over the video footage, including that which was contained in the 1st and 2nd videos that had been played in open court. Once his examination in chief, cross-examination and re-examination were completed, the respondent once again posed questions to him under the guise of obtaining clarification. 19. Her questions related to the theft of the laptop which was no longer available, and she in particular queried its ownership and upon what basis he could say that the actual laptop that had been stolen was the one that had been used to record the footage in these 2 video clips. He then said that they had identified it by virtue of its serial number. The respondent then asked him who were Nkomo and Kwata. He replied that they were one and the same. She then asked him if he still had the hard drive in his possession. He replied in the affirmative. She then asked him whether he was still employed at Deer Company, to which he also replied in the affirmative. 20. And the respondent then of her own accord asked him whether coming to court had affected his company. He answered that there were no tangible repercussions, but that he would rather not be here at court. He went on to say that the defendants were good clients, so it was awkward. The respondent then asked him, are they still clients, to which he responded in the affirmative. She then asked him whether he had a good relationship with me. He then confirmed that he did. 21. The respondent then asked him how it was possible that he could not identify the people in the video footage. He responded that there was no clear picture due to the fact that the angles of the footage did not show direct facial images. The respondent then remarked that he seemed uncomfortable and explained that he was. The respondent then asked him if it was the first time that he'd been asked for the footage. He confirmed that it was. She then confirmed that he was visibly uncomfortable, and he agreed that he was. 22. The respondent then asked him what had been his motivation for seeking legal advice before providing the video footage to the investigating officer. He explained that he had been caught out of the blue, and the footage actually belonged to the client. So he had thus been obliged to ensure that he was acting correctly when he provided it. He explained that he had limited authority due to the nature of his position. 23. This line of questioning further caused the second applicant and me to apprehend that the respondent was biased in attempting to assist the state by eliciting evidence to the effect that the witness was trying to assist the second applicant and me rather than the state. 24. On 1 February 2023, the second applicant and I had the clearest indication of bias on the part of the respondent when the testimony of Mr. Samuel Ntandazo Kwate had completed. During his evidence in chief, he had expressly stated that he had not seen who was shooting and that he had merely heard the gunshots when watching a video on his phone after the event. During his testimony, he clarified that the video that he had seen did not show who was shooting, that he had not heard any gunshots at the stadium at the time. 25. Once he had completed his evidence in chief, cross-examination and re-examination, he was questioned by the respondent once again under the guise of seeking clarification. 26. I pause to record here that the second applicant's counsel had not seen it necessary to cross-examine this witness. 27. In the questions relating to clarification, the respondent confirmed that he had been responsible for the graphic display but had not watched the event. She then put to him that she presumed that he knew who was present on the stage at all times. He replied that he did not know who had been on the stage at all times. She then asked him whether the people changed. He replied that they did. There were a lot of activities, so people came in and went out. 28. The respondent then requested that the first and second videos be played for the witness without sound and that the operator must pause the video when she told her to do so. The first video was played, and after having the video paused and having the witness state out loud that each person was wearing at least one clothing item, she told the witness to look at the far left corner and see what the person was wearing. The witness said that that person was dressed in red. She then told the witness that that person was also wearing jeans. He agreed. She then told him to look carefully and see that the person had a red, long-sleeved, buttoned shirt with a collar. The respondent then pointed out that the other people on stage were wearing red jackets and tops, but not red, long-sleeved, buttoned collar shirts. 29. The respondent then asked him whether that person had anything in his hand. The witness moved closer to the screen and the operator utilized the cursor to point to that person's hand, which elicited a response from the witness that he could see something. The respondent then asked the witness whether he could describe what was in the person's hand. He responded in the negative. 30. This questioning resulted in the second applicant's counsel objecting to this line of questioning. My counsel also objected and placed on record on my instructions the various incidents which had occurred and that I may apply for the refusal of the respondent. Reasonable apprehension of bias. 31. I became upset and stated the respondent was prosecuting and not doing a job as a magistrate to clarify issues. There is no doubt in my mind that this line of questioning is intended to assist the prosecution in proving the allegations against the second applicant and me. I thus have a reasonable foundation for my apprehension of bias on the part of the respondent. 32. The respondent attempted to explain that she did not overstep her authority. Our counsel then requested a short adjournment. The prosecutor approached my counsel and requested that regardless of what action we decide to take, we complete the evidence of the current witness. My counsel then placed this on record. 33. The respondent who at that stage reported that she had already completed her questions and asked further questions of the witness relating to the previous witness, Sibusiso, and what his position at Gear House was. She then also asked the witness what his position and responsibility in at Gear House entailed. Thereafter, she asked whether he had checked all the equipment and whether anybody had reported any problems. 34. Subsequently, my counsel put to the witness that prior to the respondent's questioning, he had not noticed the red long-sleeve buttoned collar shirt, whether that person had anything in his hand, and had not known which people had been on stage. He conceded that this had been the case. 35. During the course of the exchange between the respondent and the witness, the respondent was saying things to him to which he had responded, "If you say so." 36. It was very clear to all present that the respondent was attempting to get the witness to identify either the second applicant or me on the relevant video clip. It is further evident that she had taken a stance that was not in my co-accused and my favour, but clearly aligned to that of the state. 37. After a few further questions by the respondent to the witness regarding the witness Mkobo and the role of a senior audio-visual technician and whether any problems had been reported to this witness on the day in question, the matter was adjourned for the argument of this application for the respondent's recusal. 38. The cumulative effect of the respondent's questioning of the last three witnesses under the pretext of seeking clarity is that these questions clearly favoured the state and prejudiced the second applicant and me. There can be no doubt that these questions were aimed at bolstering the state's case against us. We thus have a reasonable apprehension of bias and do not believe that we will receive a fair trial before the respondent. 39. When these events took place in court, members of the gallery also expressed similar views and were quite vociferous in claiming that the respondent is prosecuting, if not persecuting us. Submissions. 40. I've been advised to and respectfully submit that the established principle in our high courts is the effect that the second applicant and I are required to establish a factual basis for a reasonable apprehension of bias. 41. Due regard being had to the respondent's conduct as detailed above, I have no doubt that all of the questions posed by the respondent are not aimed at seeking clarity, but rather to assist the state and to fix or bolster its case against us. 42. Further legal argument will be addressed to this Honourable Court in this regard on our behalf, but I have been advised to and respectfully submit that the most recent decision by the Honourable Justice Kun in the matter of the State versus Jacob Gekisa, Zuma and TEL South Africa Proprietary Limited deals in great detail the legal principles to be applied and ought to be followed in this regard. 43. I specifically refer in this regard to the legal principles applicable to such an application that was set out in paragraphs 22 to 49 of that judgment, which end with the following, quote, "The question is whether the alleged manifestations of bias, viewed either singly or collectively, would give rise to a reasonable apprehension of bias on the part of a reasonable, objective and informed person. Factors raised, if considered individually, might not in and of themselves be a sufficient indication that a litigant would not be perceived to have a fair hearing. But taking cumulatively, the complaint that it is reasonably apprehended that the judge will not bring an open and impartial mind to bear on the adjudication of the matter might be justified." 44. Finally, Kun J referred to the leading South African commentaries on criminal procedure in paragraph 83 and held that, quote, "The integrity of the judicial process must be protected against any reasonable taint of suspicion so that the public and litigants may have the highest confidence in the integrity and fairness of the courts." 45. I therefore, on behalf of the second applicant and myself, having been duly authorized to do so, pray for the relief sought in the notice of motion annexed here 2. It's then signed by the deponent, the first accused and first applicant, on the 2nd of February 2023 at East London, he having duly taken the oath. There's also, as I alluded to earlier, Your Worship, a confirmatory affidavit by accused number 2. I believe to read that onto the record. It has the same heading, Your Worship, in the second applicant's confirmatory affidavit. I, the undersigned, Gerhardus Adrian Snyman, do hereby make oath and state: 1. I'm an adult male businessman, currently employed as General Manager at Tactical Security Services CC. 2. I am the accused 2 in the criminal matter and the second applicant in the application for the respondent to recuse herself from presiding over the criminal matter. 3. The facts contained herein are true and correct and fall within my personal knowledge. 4. I have read the affidavit of the first applicant and confirmed the contents thereof insofar as they pertain to and will refer to me. 5. I specifically refer to the undeniable fact that it is obvious that the respondent's questions are not aimed at clarification, but rather at attempting to have the relevant witness identify me. 6. Additionally, the fact that the video in question was not created by Gearhouse means the respondent was using this witness to attempt to identify me as being the person in the video. The fact that he had no knowledge of that video and did not know where or when it had been created or by whom means that her questions were inappropriate and solely intended to bolster the state's case against me in particular. 7. I accordingly asked that the relief prayed for, the notice of motion to which this my confirmatory affidavit affixed, be granted as prayed. It's then signed by that department as well. Also on the 2nd of February 2023, having duly taken an oath which was signed by the Christian votes. That's the factual basis, Worship, that's before your Worship. As I alluded to earlier, I would like to address your Worship with the latest states on the law. We also, your Worship, have a copy of that judgment by the Mr. Justice Quinn and a few other articles and judgments that we beg to leave, which we beg leave to hand up in due course. Thank you, Worship.
Thank you. Advocate Matthews.
Thank you. I confirm that the affidavit of the second applicant has been read into the record by my learned colleague. And I refer specifically to paragraph 14 of the first applicant's affidavit as reiterated in paragraph 6 of the second applicant's affidavit. While we are dealing with the grounds of this application, I may state the following provision. We are all aware that the proceedings in this court are being recorded, and it therefore is not difficult for us to obtain a true version of exactly what was said and what was not said. I have thought carefully about this and have tried to find any conceivable reason why your worship would refer Mr. Ingaba to the third video and ask him the questions which have been set out in paragraph 14. Trying to keep an open mind to establish as to whether this might be some other clarification of the issue. We should not lose the fact that in his evidence in chief, Ngcobo distanced himself from that video, clearly stating it was not a clear video, that they did not have cameras on the back of the stage, and that he himself could not even identify where or when this video was taken. It is obvious to me and my client, Your Worship, that the sole purpose of your questioning of that particular witness under the circumstances that it took place was nothing other than an attempt by you to get Mr. Ingcobo to not only identify Mr. Malema on the video, but also to identify the second applicant, Mr. Snyder. The reason I'm saying this is because we may as well have asked somebody from the street to come inside, look at the video and say, now, can you identify anybody on this video? And when we look at the precise words that you used, is there anybody in this video that stands out for you? No. I'm looking at this and I'm wondering now, why are you asking that? What conceivable reason could the court want to ask that type of question of this particular witness? In the light of the fact of his previous evidence, he knows nothing about this video. And the only conclusion I can come to is that you wanted Mr. Ingcobo to identify the accused, number 2, as being part of that video. Now, that's not clarification, because you're not clarifying something Mr. Ingcobo said. That is a direct attempt to assist the state in its proof of the case against the accused. Now, number 1 and 2 and first and second applicants in this matter. We've looked at this over and over and over to ensure that as an officer of the court, I should not stand in this court and accuse you of doing that. However, I can only, with respect to my client and myself and anybody else, attorneys that could watch that particular clip, the only conclusion we can draw is that you entered into the arena, you should not have done so, that whether your purpose is bona fide or not, and as we will see in the legal argument to follow, actual prejudice is not necessary in a recusal application. Where is the reasonable perception of bias from the accused, then a presiding magistrate must recuse herself. It doesn't have to be actual bias. It doesn't have to be your worship. I don't have to stand here and say you are actually biased. What I'm saying to you with respect is that because you did that, it has created the impression with the reasonable accused that I'm not going to receive a fair trial. You could see by the reaction of accused number 1 that he immediately thought that that was so. What happened after Mr. Nova's evidence, because it was at the end of the day and we adjourned till the next day, is not something that your worship would even be aware of. But immediately there was a problem. It was accused that I was not looking after the interests of my client because I should have objected to that kind of questioning there. I left it though because I thought there might be some other reason that would follow why you had asked those questions. But even, as I say, Your Worship, even if you were bona fide in asking those questions, it has created a reasonable apprehension that you're not going to be impartial in this particular matter. We must never forget, Your Worship, that the legal system, the justice system, played a very important role in enforcing legislation and other aspects in our darkest days. There is a suspicion among many people of the judicial system. It is very, very important. And we see ourselves as the last bastion of hope in this country, that we can impartially and without prejudice to any person because of who he is, what color he is, we will apply the law perfectly. And unfortunately, my lady, when this happens, something of this nature, the perception is created, many perceptions are created. And without saying directly that you are biased, I submit that these factors have created the impression that you are biased, and would ask my lady to recuse herself from this matter. There's no prejudice to the state. If they wish to again proceed with the matter, they can do so. Thank you.
Thank you. Advocate Caesar, do you want to address on the factual issues raised now, or once the legal arguments are taken place by Advocate Odes and Matthews?
I will do once everything has been completed. I will, yes.
Are you then ready to proceed with the law? Thank you, Advocate Odes. You may proceed.
Bishop, I want to make it very clear that this isn't an attack on the worship, the person, or the integrity of the worship. As my learned friend has stated, this is premised upon a reasonable apprehension of bias on the part of the accused. These applications, worship, are the most difficult applications to bring. whilst an application for leave to appeal might be seen as an attack on the confidence of a judicial officer, these applications are often perceived to be an attack on the competence of the presiding officer. This is not the case here, Your Worship, and I could very definitely not. And I say that on a personal and professional basis. Worship, the case law dates back centuries, but I'm going to just try to extract basic principles and try to come forward in time to as recently as a few days ago, as I already alluded to, the decision by Justice Kuhn. And there's also a very recent decision in this division, and they conclude differently, but they are distinguishable, and I'll make it very clear. So my starting point, Your Worship, would be the principle that was enunciated in the Transvaal Provincial Division decision in 1943, Slade versus Pretoria Range Board. It's reported at 1943 TPD 246 at page 252. It states as follows: judges who are recused and submit to be recused do not necessarily admit that if they had to go on with the trial, they would do an injustice. That's the principle that I want to expand on as we go. So I'm not saying that Your Worship's continuation of this trial will result in an injustice. I am concentrating, Your Worship, on the perception that was created in the mind of the accused. And it's comparable, Your Worship, to the second case that I referred to, which is a reported case of 1996. It's a decision of Lynn and Mock versus Ned Travel. It's cited as Mock versus Ned Travel. Reported, Your Worship, was a decision of the Supreme Court of Appeal at 1996, volume 3 of the South African Law Reports, page 1. That involved a dispute, Your Worship, between an attorney by the name of Alan Levine and an acting judge by the name of Dennis Fine. And the appellant there had gained the impression that she would not receive a fair trial because of the animosity between these legal practitioners and the further practitioner Sola. And the acting judge Fine had disbelieved her, and she said that was on account of the fact that there was this animosity. There was no outward manifestation of it. In the full bench decision given by Mr. Justice Hefer in the Supreme Court of Appeal, he alluded to what is now referred to as the reasonable apprehension of bias on the part of a presiding officer. So, whereas the application had been dismissed by the first judge as being frivolous and being disbelieved and possibly scandalous in mala fide, the Supreme Court of Appeal eventually found that the reasonable apprehension of bias was sufficient to justify a recusal. There are numerous cases that then follow along that line. There's a case of President of the Republic of South Africa versus SAFU, which is the leading authority. That in turn is the decision of the Constitutional Court, which is referred to in all of the leading authorities on this point. And I make it very, very clear, as my learned colleague had alluded to, that there's no need to actually prove perceived or actual, to prove actual bias. It is the mere reasonable apprehension of bias that suffices in the circumstances. These decisions have been followed, Your Worship, in the recent decisions, and it's important. It would take all day to go through all of them, but I'm only going to highlight a few. For the principle, there's the case, Your Worship, of Silwana and another versus Magistrate for District of Picketsburg and another, 2003, 3 All South African Law Reports, page 350, a decision of the Cape Provincial Division there. What had happened was it was established that the magistrate had signed search warrants pertaining to a matter. The relevant parts relating to the accused had been deleted from the affidavits that were placed before the magistrate, so the magistrate felt entitled to proceed with the trial against the accused. and on appeal, the Cape Provincial Division to set aside because of the need to ensure that there is no perception of bias on the part of the magistrate. The next case, Your Worship, is one of Vatopwa and others versus Magistrate Vila. It's got EHILA and another. It's a Zimbabwean decision, Your Worship, 2010, JOL 26251ZH. In Harare, Your Worship, where it was a decision of the Honourable Justice Ukeris, but UCHERA. What had happened there, Your Worship, is the counsel were missing from court. There were passages. The presiding magistrate walked into court and asked the accused what was the basis of their defence. The accused then explained the basis of their defence, and that was then found to have been an improper questioning, and it was held that the presiding magistrate ought to have recused himself, obviously didn't, which resulted in the appeal. The last factual case before I go to the more recent cases of the article, Your Worship, is MM versus Magistrate Fatima Khan and others, a decision by the Honourable Mr. Justice Hendricks as the DJP in Nahi King High Court on the 3rd of December 2021, which involved a family law matter where the one party had come before the magistrate and she suggested that the person utilised a particular attorney, she then did so, the matter then proceeded. This was brought to the attention once again as a refusal to accuse, which resulted in an appeal that succeeded. But Your Worship, that's all illustrative of the principles, and I'd like to home in, Your Worship, on more recent authority. Firstly, Your Worship, there is a very, very informative paper by Justices Cato Regan and Edwin Cameron, former justices of the Constitutional Court. I have a copy for my learned friend and for Your Worship, which I will give to hand up.
Thank you.
Your Worship, I'm not going to read the whole article out to you, so I'm just going to highlight basic principles that they deal with the principles that we refer to. So in the introduction, Your Worship, the learned justices write as follows. The South African Constitution confers extensive powers on the South African judiciary to uphold the rule of law. In so doing, it stipulates that courts must be independent and subject only to the Constitution and to the law, which judges must apply impartially and without fear, favour or prejudice. That's section 165 sub 2 of the Constitution, Your Worship. Judicial impartiality is thus a principle at the forefront of the Constitution, but it was also deeply embedded in South African common law. So it's not something new that arose on account of the Constitution. The Constitution is merely a recognition of the common law in this regard. At page 2, under the heading General Approach to Recusal, the judges state as follows. As in many Commonwealth countries, it is generally accepted that there are two circumstances in which a judge must recuse himself or herself. The first is where the judge is actually biased or has a clear conflict of interest, and the second is where a reasonable person in possession of the facts would harbour a reasonable apprehension that the judge is biased. So one is an overt attack, the other one, an overt act, the other is not. And we're dealing here with the perception created in the mind of the accused. And these accused. And as I alluded to earlier, Worship, they refer to their decision at page 5 in presence of the Republic of South Africa versus South African Rugby Football Union, and quotes as follows. Whether a reasonable, objective and informed person would, on the correct facts, apprehend that the judge has not and will not bring an impartial mind to bear on the adjudication of the case, that is a mind open to persuasion by the evidence, the submission of counsel. The reasonableness of the apprehension must be assessed in the light of the oath of office taken by the judges to administer justice without fear or favour, and their ability to carry out that oath by reason of their training and experience. It must be assumed that they can disabuse their minds of any irrelevant personal beliefs or predispositions. They must take into account the fact that they have a duty to sit in any case in which they are not obliged to recuse themselves. At the same time, it must never be forgotten that an impartial judge is a fundamental prerequisite to a fair trial, and the judicial officer should not hesitate to recuse herself or himself if there are reasonable grounds on the part of the litigant for apprehending that the judicial officer, for whatever reasons, was not or will not be impartial. You also at page 7, under the heading The Chimera of Absolute Neutrality, they acknowledge, Your Worship, that it has long been recognized that no judge can be absolutely neutral. Judges are unavoidably influenced by the society in which they live, and they refer to experiences in that regard. At page 9, at the foot, there's a heading, Your Worship, Determination of Reasonable Apprehension of Bias on Facts. And then there's a quote at the top, well, I quote, I beg your pardon, from the top of page 10 as follows. The question whether there is a reasonable apprehension of bias must be determined on the facts before the court. So in considering an application for recusal, the court should ignore incorrect assertions. A challenge based on inaccurate information can therefore not succeed. And I will show you also that's one of the distinguishing features between the two recent cases that I will allude to in due course. Worship, at at page 12, under the heading Conduct of Proceedings, the learned justice is stated as follows. As in most Commonwealth jurisdictions, the judicial officer's conduct during the proceedings may found review or appeal proceedings afterwards. There is a close overlap here between the rules governing recusal and the constitutional right to a fair trial. The latter is entrenched in respect of civil trials in section 34. Everyone has the right to have any dispute that can be resolved by the application of court decided in a fair public hearing before a court or, where appropriate, another independent or impartial tribunal or forum. In respect of criminal trials in section 35 of the Constitution, rights of those arrested, detained and accused. A judicial officer presiding over criminal proceedings is not merely an umpire, and the criminal proceedings are not a game. The judge is there to ensure that justice is done. Thus, as the Supreme Court of Appeal recently remarked, fairness of court proceedings requires of the trial to be actively involved in the management of the trial, to control the proceedings, to ensure that public and private resources are not wasted, to point out when evidence is irrelevant, and to refuse to listen to irrelevant evidence. A supine approach towards litigation by judicial officers is not justifiable either in terms of the fair trial requirement or in the context of resources. On the other hand, the learned authors continue, a judicial officer must strive to ensure that those involved in the trial perceive the conduct of the trial to be fair. These potentially countervailing requirements mean that a judicial officer must walk the thin dividing line between managing a trial and getting involved in the fray. There's a reference, as your worship will see, to the Mark case that I've referred to at the foot of that page. But I'll then turn to page 14, your worship, where the reference states as follows. Where, it's in the second paragraph, your worship, where the judicial officer gets so involved in the fray that it results in a reasonable apprehension of bias, the ordinary but not inflexible procedure is for a dissatisfied litigant to pursue the complaint by way of appeal or review once the proceedings are complete. As Shana J.A. observed in R. vs. Silva, the grounds related purely to what had happened in the course of the trial. Neither counsel has been able to find any reported case in which an application for recusal had been made in the course of the trial on the ground that the judicial officer has shown bias by his conduct of the proceedings. And this is not surprising, since the ordinary way of meeting any apparent bias shown by the court in its conduct of the proceedings would be by challenging his eventual decision in an appeal or review. And finally, your worship, the conclusion on page 17. The principle that judges must act impartially without fear, favour or prejudice is foundational to South Africa's constitutional order. In developing a jurisprudence based on this constitutional principle, South African courts are fortunate to have both South African common law jurisprudence upon which to build, as well as the jurisprudence of many other jurisdictions. particularly in the Commonwealth, as this chapter is illustrated. Cultivating a habit of impartiality and open-mindedness is a continuing task for judicial officers in every democratic state. Nowhere is that task more important or difficult than in recusal applications. It will indubitably be made easier by studying how judicial colleagues in other jurisdictions address the questions they raise. So, Your Worship, even they recognize how difficult the task is that they have at the government, and that they go through the principles which are enlightened. The next decision, Your Worship, is the decision in this jurisdiction. It's a decision of the Eastern Cape High Court, sitting at Bishop, a decision of Mrs. Justice Stretch. I believe to hand a copy of that judgment.
Nkolo versus the state?
Yes, Your
I do have a copy. But I would, maybe I might, thank you.
Your Worship, there, Your Worship, the issue was that the trial was being unreasonably delayed by the defense in what's been colloquially termed in South African parlance as the Stalingrad defense, and the judge had refused further postponements and wanted to go to trial. There was then a recusal that was premised upon 3 basic averments, and these are captured, Your Worship, at page 3 of the judgments as being the following. The first was that the presiding Judge Stretch had indicated in the presence of the applicant's newly appointed counsel and the prosecutor that she was not prepared to entertain any further applications for the trial to be adjourned. Secondly, that she had informed the applicant's attorney that she was not Kunjay and that the applicant was not the former President Jacob Zuma, which is very ironic with what's now transpiring, what I'm going to be referring to. And thirdly, that during the course of exchanges with accused two's attorney, who was also moting for a delay in the commencement of the reading of evidence, pending representations which accused two was making to the Director of Public Prosecutions, she had said the following, and I need to just quote this. She said, "You know, Mr. Skumbi, what concerns me is this is a serious matter. We all know that it is a serious matter. The media here, they consider it to be a serious matter. It's been 8 months since the final indictment was served, and the accused are taking opportunity after opportunity to come up with last-minute excuses as to why the trial should not go on. Prima facie, I believe that this is a delaying tactic. I thought that to traverse this in my chambers this morning was to canvass this with one of your colleagues, and was told that there would then be an application for me to accuse myself. I don't know whether that is still going to be pursued, but the point is simply that this court cannot be seen to approbate and reprobate. It makes a mockery of the rule of law. It makes a mockery of the judicial system. It makes a mockery of President Mandela's funeral and corruption that apparently took place at that time. And I think people should start seeing this a little bit more seriously. And I'm not shouting at Mr. Spoon, I'm speaking to everybody in this room. So it was clear what was being dealt with in that instance, and it was endless, limitless endeavors to postpone the trial and the determination of the presiding judge to proceed with the trial. She then gave a judgment where she also refers back to most of the cases that were referred to in all of the previous cases, but she makes it clear that where there's an apprehension of bias, it must be a reasonable one borne out by the facts. This is from paragraph 15 onwards, where she makes this very, very clear. At paragraph 18, she then explains the facts of that matter, and she goes further to take issue with the manner in which they had proceeded, and this is in paragraph 18, and she says, I must at the outset point out that the attorney who has deposed to the affidavit in support of the application, and the applicant himself has deposed to a brief statement headed confirmatory affidavit, did not accompany counsel when I was approached in chambers. Indeed, as the papers stand, there is no reliable evidence enough before me as to what transpired in chambers. So it would seem, Your Worship, that what we normally regard as sacrosanct has been discussed in chambers on a professional and the basis of integrity was being alluded to by people that weren't even in the meeting. You know? One can understand that one takes issue with that type of an approach in open court. If we discuss something in chambers with your worship or anybody else, any other presiding officer, it's not for an attorney or a client who wasn't there to then refer to that in an affidavit, and it's obviously hearsay and unreliable. So then, your worship, as I said, the matter dealt with all the delays, set out a very detailed timeline, and in paragraph 20 on page 15, she states as follows. Having set out this timeline and having illustrated that this court has on a number of occasions, in the exercise of its discretion, bent over backwards to accommodate the applicant and his co-accused, I have some difficulty in understanding what basis the applicant's attorney, even if his evidence in this regard were to be admissible, can suggest that this court was not going to be persuaded any differently. So there's a clear, with respect, distinguishing feature there, worship. She made it clear, Justice Stretch, that she had bent over backwards to accommodate these people on previous occasions, as detailed in all of the events alluded to in the timeline. At 21, I'm now repeating myself, but she says that this is also not the end of the matter. It is the applicant himself who must allege and prove bias or perceived bias. And then she says that this would not be adequately dealt with in a confirmatory affidavit. And she also refers to the quote relating to Justice Kuhn at page 18, in that he had been very generous and devoted time and heard the dilatory delaying application. And at 26, in paragraph 26, she refers to repeated applications, she repeated adjournments, pending the outcome of repeated collateral issues. And we all know that this was in clear reference to the stolen defense. And then she concludes in 35 that the application was not supported by the facts or by the context. Now we say with respect, Your Worship, that the facts in that matter are clearly distinguishable. It was prior to the trial commencing. There's also a decision by Justice Stretch in which you actually separated the trials. So one cannot, with respect, draw a parallel between that case and this case. We say the more appropriate case, Your Worship, is the more recent case that was alluded to there, but hadn't come into existence at that stage, of Justice Kuhn in KwaZulu-Natal, Pietermaritzburg Court. Your Worship, I'm just going to put a clip of it. We'll have a copy for Your Worship.
Thank you.
Now, we say that this is the most recent decision and the most appropriate decision that ought to guide this honourable court in this regard. Worship, it relates to the matter in which there was a Stalingrad defence that's been referred to by Justice Stretch, and the Honourable Mr. Justice Kuhn alludes to this at page 5, paragraph 12. He says, I have for some time, following previous adjournments and the possibility of a private prosecution being launched, been concerned that certain conclusions and comments expressed in my previous judgments might require my recusal, specifically in the context of the ongoing constitutional imperative that Mr. Zuma must receive a fair trial. They say there are things that I may have said in previous judgments, be they interlocutory or final judgments on other issues, that in the context might result in the accused there not being given a fair trial, or the perception being created in his mind that he would not receive a fair trial. At paragraph 15, he refers to the grounds of the recusal, And on page 8, line 3, he says, the collective impact of my comments in the aforesaid respect should also not be ignored. So it's not just the one comment, it's a combination of comments that result in a collective impact, as is the case we submit in this instance, Your Worship, with all of the instances of question is alluded to in the affidavit of our client. Your Worship, at page 10, above paragraph 22, as detailed in the affidavit, the learned Justice Quinn deals with the legal principles. And at 22 he says, I'm enjoined by my oath of office to ensure that inter alia that Mr. Zuma receives a constitutionally fair trial, to regulate the management of the trial, to preserve the integrity of the trial, and to ensure the proper administration of justice. The issue whether any accused receives a constitutionally fair trial as guaranteed in terms of the Constitution is an inquiry that is paramount and something that should be ever present to a judge's mind during a trial. The integrity of any trial must be beyond any criticism or reproach. It is my task to ensure that the current trial also meets that expectation. A reasonable perception of fairness is all pervasive. So it's not whether you or I or any other party realizes that you're doing something wrong. It's the fundamental, constitutionally recognized right of an accused person to reasonably perceive that the trial will be fair. 23. The broad considerations to be considered in a recusal include inter alia the following. A court must ensure that public confidence in the justice system is maintained and not eroded. B. Litigants should leave the court with the sense that they were given a fair opportunity to present their case, that they received a decision that is not only actually but also perceived to be fair, dispassionate, objective, and free of bias. 24. Full confidence in the judicial system is essential for the preservation of the rule of law, a vital component of our constitutional democracy. The rule against bias is anchored in the confidence which the public reposes in the judicial system. It reflects the fundamental principle of our Constitution that courts must not only be independent and impartial, but must be seen to be so. The requirement, if not explicit, then certainly implied in the Constitution. In Basson versus Hijo, it was remarked that the rule against bias is foundational to the fundamental principle of the Constitution that courts as well as tribunals and forums must not only be independent and impartial, but must be seen to be so. The constitutional imperative of a fair public hearing is negated by the presence of bias or a reasonable apprehension of bias on the part of the judicial or presiding officer. And then they continue the quote from the Supreme Court of Appeal, but in paragraph 25 he stated as follows. Two very important aspects arise whenever the subject of recusal arises. The first is the presumption of judicial impartiality, which has been described as a cornerstone of our legal system, and the second is the test to be applied to determine the circumstances in which a recusal application should succeed or fail. In the final analysis, the question of recusal invariably turns on whether it is factually indicated. In 26, he refers to the Safu decision that I've referred to, and in the second last line, he goes from the quote as follows: at the same time, it must never be forgotten that an impartial judge is a fundamental prerequisite for fair trial, and a judicial officer should not hesitate to recuse herself or himself if there are reasonable grounds on the part of the litigant for apprehending that the judicial officer, for whatever reason, was not or will not be impartial. In 27, it goes through the grounds of recusal from the Safu matter and refers to Sakawa versus Irvin and Johnson, and says there that amongst others we further require either a proof that the judicial office is actually biased, or B, an apprehension of bias on the part of the judicial officer, and whether such apprehension is that of a reasonable objective or informed person based on the correct facts. 28. Our law does not insist on the proof of actual bias on the part of the judge. The appearance or a reasonable apprehension of bias, if proved, is enough to vitiate the proceedings. As has been said, the court will not inquire whether the judge did in fact favour one side unfairly. Where the allegation is reasonable apprehension, Pinochet number 2 held that where the impartiality of the judge is in question, the appearance of the matter is as important as the reality. Thus, it is no answer for the judge to say that he is in fact impartial, that he abided by judicial oath, and there was a fair trial. The administration of justice must be preserved from any suspicion that a judge lacks independence or that he is not impartial. If there are grounds which would be sufficient to create in the mind of a reasonable man a doubt about the judge's impartiality, the inevitable result is the judge is disqualified from taking any further part in the case. No further investigation is necessary, and any decisions he may have made cannot stand. Then it goes through, Your Worship, in paragraph 30 to Article 13 of the Code of Judicial Conduct. It says that, not surprisingly, it likewise requires that a judge must recuse him or herself from a case if there is A, real or reasonably perceived conflict of interest, or B, reasonable suspicion of bias based upon objective facts, and shall not recuse him or herself on insubstantial grounds, and here adds his own emphasis. At the foot of paragraph 31 of the dealing with the facts, there it says the issue more correctly is purely whether there is a perception of a reasonable apprehension of bias arising from findings and views necessarily previously expressed by him. Then goes through the cases further. In the paragraph 34 on page 16, it says, previous decisions are helpful to demonstrate the application of the principle, but ultimately every case turns on its own facts. The test and characteristics of the reasonable observer have to be applied to the specific factual situations in each case. At 36, the perception, appearance, or apprehension of bias is as important as actual bias. He explains why it's so important. There's then a reference in 37 to the decision of Bernard versus Absa Bank Limited, which dealt with an apprehension of bias, and says, this case, it's a quote, this case concerns the apprehension of bias. The apprehension of bias may arise either from the association of interest that the judicial officer is one of the litigants before the court, or from the interest that the judicial officer has in the outcome of the case. Or it may arise from the conduct or utterances by a judicial officer prior to or during proceedings. In all these situations, the judicial officer must ordinarily recuse himself or herself. The apprehension of bias principle reflects the fundamental principle of our Constitution, that courts must be independent and impartial, and fundamental to our judicial system is that courts must not only be independent and impartial, but they must be seen to be independent and partial. There's then reference to the case of South African Human Rights Commission on behalf of South African Jewish Board of Deputies versus Masuku, which also related to the principle of alleged perception of bias, which is then quoted extensively, Your Worship. If I can just quote two instances there. At the top of page 20, in dealing with paragraph 28, it says, and importantly, the decision to recuse oneself mere motu must not only be viewed from the subjective position of the judicial officer concerned, there is an important objective assessment that must be carried out, and the test in this regard appears to some extent to be a tapestry of both objective and subjective elements. Then at the foot of that page, Your Worship, within paragraph 8, there's a quote from the Safu decision, paragraph 29. The question is whether a reasonable, objective, and informed person would, on the correct facts, reasonably apprehend that the judge has not or will not bring an impartial mind to bear on the adjudication of the case. That is a mind open to persuasion by the evidence and the submissions of counsel. The reasonableness of the apprehension must be assessed in the light of the oath of office taken by the judges to administer justice without fear or favour, and their ability to carry out that oath by reason of their training and experience. It must be assumed that they can disabuse their minds of any irrelevant personal beliefs or predispositions. They must take into account the fact that they have a duty to sit in any case in which they are not obliged to accuse themselves. Then, at paragraph 45 on page 23, referring to the case of Rex, which is Barnsley County Borough Licensing Justices, ex parte Barnsley and District Licensed Victualers Association, Devlin, Lord Justice, in a judgment remarked as follows. Bias is or may be an unconscious thing, and a man may say that he was not actually biased and did not allow his interest to affect his mind, although nevertheless he may have allowed it unconsciously to do so. The matter must be determined upon the probabilities to be inferred from the circumstances in which the justices sit. Then, at paragraph 49 on page 25, starting at the end of line 3, it states, the question is whether the alleged manifestations of bias viewed either singly or collectively would give rise to a reasonable apprehension of bias on the part of a reasonable, objective and informed person. Factors raised, if considered individually, might not in and of themselves be a sufficient indication that the litigant would not be perceived to have a fair hearing. But taken cumulatively, the complaint that it is reasonably apprehended that the judge will not bring an open and impartial mind to bear on the adjudication of the matter might be justified. And having had regard to all of those cases and the facts of the matter, on page 42 at the foot of paragraph 76, the learned justice starts to conclude as follows. Reasonably construed, our findings indicate that I favour a particular interpretation of these factual issues and point to a reasonable and inevitable apprehension that if they are presented again, they will be decided by me in a similar manner. So there he had asked questions and received answers and made findings in his judgments that cumulatively considered the result of this apprehension. And then ultimately in paragraph 79, I refer to the following at page 44. The correctness of the above findings, conclusions and comments, and hence whether they were justified is irrelevant. It is the fact that they were made and what, at an objective level, their effect on issues which have now arisen or are reasonably certain to arise will be apprehended to be. And then finally, we also conclude, this give us at paragraph 83, above conclusion, His Lordship states as follows. The aforesaid conclusions require that I recuse myself from the trial. It is what the sound administration of justice, the requirements of the Constitution, and my conscience dictate. No reasonable negative inferences as to whether the trial is constitutionally fair should be allowed to arise. Mr. Zuma argued that it is not enough for a judge to be just in his judgment. He should strive to make the parties in the community feel that he is just. He owes this to himself, to the law, and to the position he holds. That submission is correct. The integrity of the judicial process must be protected against any reasonable taint of suspicion, so that the public and litigants may have the highest confidence in the integrity and fairness of the courts. So now, applying these principles, Your Worship, to the facts as alluded to, and I believe even undisputed in the affidavit of the applicant, one must not only have regard to the fact that you don't have to actually show bias, it's a reasonable apprehension of bias, and it's not that it's borne out by one simple comment or one simple gesture, but it's the cumulative effect of the instances that are highlighted there and detailed there of the questioning by Your Worship of the state witnesses and what perceived by the accused on oath to have been the case. Both of these accused state unequivocally, worship, that they have a reasonable apprehension of bias on account of the cumulative effect of the questions asked by your worship. Now, I don't attribute any direct bias to your worship, and it's not a personal attack. I need that to be understood. I would be failing in my observation of integrity to myself if I made such a comment, but if one has regard to the conduct of your worship, and your worship said to the last witness, look at the screen. Do you see what this person is wearing? And I'm paraphrasing your worship, but it was in the light of the phone, it was red and jeans. Do you see that he's wearing a button shirt with a collar? Yes. Do you see that nobody else is wearing a button shirt with a collar? Yes. Now have a look and see what's in his hand. That, your worship, with respect, even if it was never intended, and I'm not going to say that the intention was that in itself, your worship, would be the basis for a reasonable apprehension of bias in the mind of any accused person with respect. It was, I know your worship is entitled to inquire, ask questions. I know your worship isn't meant to sit there supine and not become involved. But it's the line of questioning which is best characterized with respect, and there's no sanction against it, as cross-examination, but to lead a person to draw inferences on a video that he was not responsible for in circumstances where the authenticity and veracity of the video is an issue, in circumstances further, your worship, there is no cameraman that's come before your worship and said, I filmed that video. In circumstances where your worship has ruled that there's no need to have a trial within a trial, this is real evidence, we will now examine the relevance of it and then come to a decision at the end of the case. Bearing all of those factors in account, and your worship, I need to add with respect that on top of the two videos that came from Gear House, we have this third footage that's been played before the court that nobody claims ownership of, that remains totally unknown. And it's common cause. Your worship has even recorded that the cognizance has been taken of that, but it's been played in court. Your worship, it could have been something from a fiction movie, it could have been anything that was played there because it has no basis to be played in the court. But in the light of all of those cumulative facts, the one added on to the other, added on to the other, leading to those questions that resulted in this application for recusal, be it that your worship was bona fide, be it that your worship never intended to do so, one must compile a tapestry that's both objective and subjective and attempt, as difficult as it is to get into the head of the accused or the mind of the accused persons and say, is this absolute nonsense and is there no basis for this application? Is it factually flawed? Or did these facts actually happen? Did these events take place? And did I possibly, unwittingly, create the perception in his mind that I am proving the state's case, to put it so to speak, or that I might be biased? Because all that is required at this very difficult, in this very difficult application, is a reasonable apprehension of bias. And your worship, the facts are there, they speak for themselves. I'm not attributing any mala fides to worship, but it's just the cumulative effect of all of those circumstances taken together, which distinguishes this case from the decision of Justice Stretch, in that there it was, well, this might have happened in chambers, and this is my account of what was explained to me, and this is what was said, and ought never to have been repeated, but was repeated in papers, which in itself is deplorable. So one can understand the reaction of the justice to that. But when one has regard to facts that are played out here, only in open court, your worship, and one says, right, 3 videos, these sets of questions, let's look at them. And can it honestly be said, with respect, your worship, that those factors all taken together cumulatively could not possibly have caused a reasonable suspicion or apprehension of bias on my part for me, with respect to Joseph, the answer has to be that one must err on the side of caution in this regard and not attempt to wish away the facts or push away the facts with a view to proceeding with a trial that will thereafter, in my respectful view, be tainted and with respect to the administration of justice into disrepute. I have no further address, Your Worship, unless the court wishes to hear other
Advocate May, please.
Thank you, Your Worship. I'm going to ride on the coattails of Mother who has comprehensively placed before the court what is the legal position today to this aspect. We are fortunate that we have a well reversed judgment by His Lordship Mr. Justice Cook in the matter of President Zuma. Now, he has set out in this judgment all factors which are applicable to this court. I want to highlight only one factor, that is in paragraph 44 of this judgment, where he refers to the decision of State versus David, 1991, Volume 1, South African Criminal Law Report, at page 375, in fact, an Namibian decision. And he quotes, he says, "It is no answer for the judge to say he is in fact impartial, that he abided by his judicial oath and there was a fair trial. The administration of justice must be preserved from any suspicion that a judge lacks independence or that he is impartial. If there are grounds sufficient to create in the mind of the reasonable man a doubt about the judge's impartiality, the inevitable result is that the judge is disqualified from taking any further part in the case. No further investigation is necessary, and any decision he may have made cannot stand." Brings us to the issue as to whether in this particular case, are there sufficient grounds to create in the mind of the reasonable man a doubt about your impartiality in this particular matter. I have already referred to the showing of the third tip video and the questioning between Your Worship and the witness in Marble. And I've indicated to Your Worship that after careful consideration, neither my client or I can come to the conclusion that the only reason you did that was to bolster the state's case in having him identify Mr. Snake on that video. We know that the identification of a person on the video is crucial for the state's case. And therefore it is a crucial element in the whole aspect. And the prosecutor, when leading a witness of that, leading the evidence of that witness, quite correctly didn't go to that. If he had, I would have suggested that maybe you were clarifying something, but he didn't. And we, with respect, cannot find any reason to conclude that this was clarification in any manner whatsoever, that it was simply there to bolster the state's case. If I may refer also to the the first two videos, where you addressed the witness as to the dress of a certain person on the stage who, by all intents and purposes, was the first accused. You then shifted the first accused from the position he was holding in the middle of the stage to the person who was standing on the edge of the stage. Again, insisting that the witness confirmed that the person now standing on the edge of the stage was dressed the same as the person who was in the middle of the stage. And that resulted in the fact that you are now concluding that Mr. Malema had moved to the edge of the stage. The next step you did was to say, do you see he's holding something in his hand? What is he holding in his hand? It would have been an absolute tragedy if that witness suggests he's holding a firearm in his hand. Because now he's testifying about a video you and I can look at. He testified that he'd never seen that video before. In fact, he had just downloaded the video he had, or a video. He had never actually personally seen that video. Your questions to this witness were so leading that the witness himself said, if you say so. If you say so, that is closed or that if you say so. I don't know what the purpose of your questions were, but I have no doubt that has created a reasonable, that those are sufficient grounds to create in the mind of a reasonable man a doubt about your impartiality in this particular matter. Thank you.
Thank you. Is the state ready to reply or wish to reply, Advocate Caesar?
Yes, I'm ready. I'll try to be brave. I'll try to be brief and brave. Thank you. Just on a lighter note, if the court will allow me, just speak about the personal experience I had when I attended my pupillage. I drafted a very fancy document where we were supposed to go to Stellenbosch to attend our practical training for pupillage. Arriving there, we were put into different groups. I ended up with a Hong Kong group, and where this person had to check my fancy document, and he just scratched it in front of me. I felt like slapping him at the time. But while I was doing it, he was just saying, legalese, legalese. Why didn't you simplify your argument? That's exactly what I'm going to try and do in this particular matter. Yusuf, firstly, I'm opposing the application for yourself to recuse. Just on face value of the notice of motion, in terms of Rule 55, it's my submission that it does not comply, because I don't even know whether I've got locus standi to address your worship in this application, because I was not cited as a party, and the NPA should have been cited. The Director of Public Prosecutions should have been cited, as we have a direct interest in the outcome of this particular matter. To add further, Your Worship, I only was provided with this particular application this morning at 2:10. Yusuf, the application is that you recuse yourself. I'm of the view, and it's the state's submission, that it would not be in the interest of justice that this be done. I want to there's no proper grounds placed before you, Worship. If I can cite the case, I'm going to give my learned colleagues a case. It's a matter of the state versus Daling Yebo, that's the king. It's a Supreme Court of Appeal decision. I also wish to hand in a copy to the court.
Thank
I want to cite it. It's State versus Dalindyebo. It's a 2016 in brackets 1 SACR 329. It's a decision by the Supreme Court of Appeal. They had to also deal with a particular matter where the king, Dalindyebo, have requested the judge, presiding judge, to, I think it's Elkama, my memory serves me correctly, to recuse himself. If you look at from paragraph 25 of the judgment, it doesn't have a page number. The heading of the is the complaint that the trial judge unjustifiably descended into the arena, rendering the trial unfair. If I read from paragraph 25, we now address the appellant's complaint that Elkama J repeatedly and unjustifiably descended into the arena, thereby rendering the trial unfair. It's referred to in State versus Raw, 1982, in brackets 1, SA, I must get some glasses, 8, 28, Appellate Division, at page 831, JA. The court said the following. Is your worship there?
Yes.
It said first some general observations according to the well-known dictum in Lewis, JA, in R versus Hepworth, 1928, Appellate Division decision, at page 256. It's page 265. Can I borrow your glasses? I don't know what's happening to my eyes these days. It must be age. According to the well-known, and if I quote, a criminal trial is not a game. And a judge's position is not merely that of an empire. It's one, it's not of an empire to see that the rules of the game are observed by both sides. A judge is an administrator of justice. He is not merely a figurehead. He has not only to direct and control the proceedings according to recognized rules of procedures, but to see that justice is done. So in other words, what they're saying, your worship is not only as a referee between the parties, you also have to be actively involved, and you ought to need to ask questions if you're not sure. You should not deprive yourself of the advantage of calm and dispassionate observations. If you continue down there, your worship, the judge is therefore entitled to often oblige in the interest of justice to put such additional questions to witnesses, including the accused, as seemed to him desirable in order to elicit or elucidate the truth more fully in respect of relevant aspects of the case. They refer to Wigmore on evidence, 3rd edition, volume 3. The citation is there. I don't want to go through all of that. And it's for that purpose, according to the learned author, that you may put questions in a leading form. It says simply because the reason for the provision of leading questions has no application to the relation between the judge and the witness. It is the state's submission that this is exactly what transpired. There, the learned author differentiate that relation from one between the counsel and that between the witness recalls. It says counsel is prohibited from putting leading questions to his own witness because of the risk that the witness may perhaps think that such questions are an invitation, suggestion, or even an instruction to him to answer them, not unbiasedly or truthfully. What your worship did here is nothing untoward. That you are not prevented from doing that. It's not advisable that us as the litigants, counsel for the state and counsel for the defense, that shouldn't be done, but you are perfectly allowed to do such. Bishop, the judgment go on and on and on. I just wanted to bring that up and point out that the court is totally entitled to do such. Bishop, if I can go to the factual issues briefly. From what has been put by counsel for accused number 1, that's Mr. Malema, that it's not in dispute. If I understand it correctly, I stand to be corrected. That accused number 1 did in fact, or it's common cause that he was there. Also appears to be common cause that accused number 2 was also present on the date relating to the incident. It's further common cause that from what was put to the witness that shots were fired, but from a TV or toy gun by accused number 1. If I understand what was put correctly, I'm standing to be corrected. If that is the case, the only issue that ought to be decided at the end of this trial is whether that indeed was a real firearm. The crux of this case is whether it was a real firearm or whether it was indeed a toy or TV firearm. That's the crux of the case. What your worship did and didn't do, it's to me it's very simple. That's all you have to decide in this particular matter. There's no proper grounds before your worship. Worship, I want to read from a article by a particular judge. It's very short. My laptop is just locked. Where in the High Court of Gauteng Local Division in Johannesburg, it's a case number SS 40 of 2006 in the matter of Bennett Susan Hillary. It's Susan Hillary Bennett, but it's said the way it's Bennett Susan Hillary. And the second, that was the first applicant referred to in accused as accused number 2. The second applicant, it's Porrat Gary Patrick. So it should be the other way around. Gary Patrick Porrat is the second applicant. He was or she was accused number 2 in that matter. Where the Judge Perk J gave a very brief judgment on a recusal application. He said both the Constitutional Court and the Supreme Court of Appeal honed the legal requirements down to include at least a double reasonable test based on a consideration of the correct facts. An apprehension of bias can only arise if it is founded on the correct facts. In other words, if a factual foundation is wanting, then the apprehension is misplaced that will end the inquiry. I'd like to just say I'm still talking. I don't know what this counsel talking here, Your Worship. It's a distraction. It's causing a distraction.
I'm correcting or turning on something that's happening on the mean to disturb and apologize.
Apology accepted, Your Worship.
Thank you.
The judge remarked that there's also in the recusal application there's responsibilities on legal representatives. We tend to complicate everything as legal representatives. If you go to the public now and go ask them about what they think about lawyers, the answer you would not like, because we complicate everything. There's more and more recusal applications are brought as a tactical device or simply because the litigant does not like the outcome of an interim order made during the course of the trial. It's our submission. This is exactly what is happening here. An interim order that was made by Your Worship regarding the videos, and they do not like the outcome. The lack of discernment with which recusal applications are being launched or threatened is a cause of concern. It's more and more in these contentious cases. It's time to take a stand. Your Worship, the recusal of a presiding officer, whether it's a magistrate or a judge, should not become standard equipment in a litigant's arsenal, but should be exercised with its true intended objective, which is to secure a fair trial in the interest of justice in order to maintain both the integrity of the courts and the position they ought to hold in the minds of the people who they serve. The risk of recusal applications being used as a strategic tool is that far from securing the integrity of the court. Continually unfounded aspiration on judges may bring about a loss of faith in the judiciary as a whole and bring it into disrepute. You Worship, in this regard, there is an onus on We are now into motion applications now. We're no longer dealing with a criminal trial. Rule 55 in the Magistrates Court rules is applicable here. We're dealing with applications. He who alleges must prove. Bishop, there's no proper grounds for this particular application before yourselves. I'm not going into all the legalese and so on. It's already been done by counsel for accused number 1. Bishop, accused number 2, on Monday when I entered here, he approached me and I didn't want to go, and he said, I want to see you in front of his legal representative. He said, I want this trial to be finalized. And I said to him, I'll try my best. My submission is that you being recused from this particular matter is not in the interest of justice. It's going to prejudice not only the accused but also the state. There's no sign of bias here. Even if there was, Your Worship, there's sufficient safeguards in the Criminal Procedure Act. If I refer to, if there was alluded to by accused number 1, what I would suggest, Your Worship, or what my submission is that counsel ought to have brought an application to make a special entry with regard to this issue, or they've got review or appeal as remedies. It is my submission that you should dismiss this application. Anxiety on the part of the accused is not sufficient grounds. That is my submission. I've got no more.
Thank you.
I don't need to be condescending. I did express an apology because I didn't have intent to comment about or disturb the prosecutor. That Worship, this response to the farmer's project. Let's start off at the tail end, if I may, Worship, because those are the clearest examples. For an advocate, former magistrate, and I don't mean to be personal, Worship, to tell this court that the correct procedure, when you feel prejudice, because there are sufficient safeguards in the Criminal Procedure Act, is to apply for a special entry. I challenge you, Worship, to show me where in the Criminal Procedure Act one can apply for special entry in the Magistrates Court. It doesn't exist. Special entry, if I remember certain correctly, is in the section 316 to 318 of the Criminal Procedure Act and only applies in the High Court. There's no such thing in the Magistrates Court, and I personally challenge you in that regard. To my mind, I've been practicing a few years and I've never ever heard of it. So I don't know why when you feel prejudiced or biased, there's sufficient safeguards in the Criminal Procedure Act that you can apply for a special entry is nonsensical, and I don't need to be personal. To further say that you can go and review or appeal is equally contestable, Worship, in that one cannot go and review until one has a decision from this court. Even then, there are lots of authority that say, Worship, that one must wait until the proceedings have been completed. And there's a tendency against going and reviewing part of litigation. There are instances where it has been allowed. Authorities, Worship, are well asked, but WAHL, HAUS says you shouldn't delay proceedings by going on a review part heard. there was an exception to it in the Berman versus additional decision. It was allowed, but one has to make out the basis for doing so in part two proceedings. And when it comes to an appeal, Your Worship, one needs leave to appeal first from Your Worship on every aspect of the law. So I don't want to sound disrespect for Your Worship, but I am, to say the least, astounded by his response to the Tribunal. Worship, the test remains sacrosanct in our law. It has been established straight. It's trite, it's there. There must be bias or a reasonable apprehension of bias. The interest of justice is not a test to apply. It's one of the factors that can be taken into account in applying the test. Additionally, Your Worship, I understood, and I still find it hard to actually believe, that he said that litigants shouldn't use leading questions. It's not advisable to them, but presiding officers may. Assume I've heard him correctly, otherwise he'll correct me. And I've never heard of anything more ludicrous, especially to somebody who refers to his personal experience and pupils, because the art of cross-examination is the utilization of leading questions. The skill of examination in chief is that you're not allowed to use leading questions. We as defense counsel are obliged and to be following our duties if we can ask leading questions, so I don't understand the responses. Worship, if one has regard to the spoiled decision in Bennett and Porritt, it was very similar to that of Stokes there. It was litigants, involved litigants that were, so to speak, employing a starting grade defense that were in circumstances where the trial only began 15 years after the fact. They avoided court, they took chances getting sick. It's another record. It doesn't have any application to your respect, Your Worship. And there's a last-ditch attempt to apply for Honest Justice Court to accuse himself without setting out a proper basis for him to do so. If I'm also as regard, Your Worship, to the other decision that we quoted, the decision of State versus Daniel Jerbo, involving the chief, not the king, Your Worship. In that instance, Your Worship, at the paragraph referred to by my learned friend, the appeal court dealt with the questions that were asked by the judge in instances and found that they weren't of an interfering nature. They were simple questions. In fact, in most of the instances cited there, they protected the witness from exuberant or unnecessary cross-examination on questions that were illogical or couldn't be answered and would be regarded as being unfair. So the interventions referred to there, in most instances, Your Worship, were to protect the witnesses. That, with respect, cannot be said to be the case here. In every instance, Your Worship, the questioning by Your Worship took place after cross-examination, examination in chief, cross-examination and the examination have been completed. They have no application of this judgment, Your Worship. It wasn't an argument during the course of any form of examination. It was post the testimony when the court was seeking clarity and asked questions, and it was in that context that they were so they do not, with respect to right here. Your Worship, my learned friend has made it clear that he is aware that the videos were in dispute. Your Worship made a ruling, we abide by it. We've never taken issue with it, Your Worship. We never took you on review. We conceded, Your Worship, that there were two different approaches from the same year, from the same division, and there was a possibility of regarding the real evidence as opposed to regarding as documentary evidence. We alluded to that conflict in the law and those conflicting decisions. We argued in favor of the one, not the other. Your Worship has a discretion. But to say that this is premised on that, Your Worship, is totally out of bounds. It's not the case with respect. Whether we like your decision or not isn't the fact here, Your Worship. This is premised on a very strict factual basis, Your Worship. I also don't know how my little friend received the papers at 2:10 this morning. I can tell you, Worship, they weren't ready at 2:10 this morning. They were still being printed and hadn't been signed, so I don't know where that comes from. Your Worship, the fact that we compile documents in the limited time is a courtesy to this honourable court. My little friend is not a cited party, he's an interested party and is provided with a copy of the papers. We could very well, Your Worship, have launched an application with no papers. It was purely to detail and to provide an opportunity and in fact to show respect to the court to do so. It's not a motion proceeding, it arises in the nature of criminal proceedings. It's the criminal trial, Your Worship, doesn't get changed your gown and put on a civil gown to now start a motion court. This is a criminal matter. It's an application for recusal in a criminal matter and does not have anything with respect to do with sitting as a motion court and attracting a different onus. We have a test, a legal test that applies, that is evident from all of the authorities, from the Constitutional Court downwards, including the Supreme Court of Appeal, to show that there was bias or a reasonable apprehension of bias. He has not, with respect, even attempted to deal with it. I haven't heard him mention it even. He may refer to it in his all-encompassing reference to legalese. It's the test. I can't change it, Your Worship. That's the legal test. I don't hide behind legalese or legal terminology. That, with respect, is the test as established by our courts all the way up to the Constitutional Court, and I don't believe my friend is told him this is legalese and that it can be crossed out by his person walking his examination. Your Worship, I do not believe that there has been proper opposition to this application by the state. We stand by our application and we reiterate that the test, Your Worship, is simply no more than a reasonable apprehension of bias on the part of the accused, that is borne out with respect, Your Worship, with the factual examples given in the papers. With no further address in this, Your Worship, which is in any particular.
Thank you.
Your Worship, this morning I approached my learned friend Nada, he wants to get personal.
Sorry, I didn't hear your first part this morning.
Now that he wants to get personal. I told him that because of various factors, including, I almost want to say this useless escalation, we sat in the dark for most of the night. We have, under severe circumstances, drafted this application. I told him this morning, I'm sorry, we're going to only give it to you now. Please indicate to us if you want more time to consider it, we will gladly concede to it. Why he now mentions that he only received it at 10 o'clock is puzzling to me, because he should tell us now if he needs more time, we should stand down and he can go and do what he wants to do. His remark that there's a duty on counsel, a responsibility on counsel in a matter such as this, is the very thing that I addressed you. To say to you that we have seriously considered this, we have listened over and over to what happened, taking the advice of our clients. This application was not brought because of any anxiety on our part, because we don't like the ruling as regards the admission of the video. We didn't tell you to recall the witness. We didn't tell you to tell the witness to look at clip number 3. We didn't ask you to ask any of the witnesses to do what our conduct, that conduct which we complain about. My lady, the interest of justice is not a test. The test is set out very clearly as to what a recusal application is or isn't.
Thank you. Everyone done? Okay. what we should decide on is the time for resumption for judgment or ruling by court. If it is since I'm aiming at responding to the grounds and dealing with the law, I don't anticipate that I will need more than approximately 15 minutes court time, or I need preparation time. So, quarter to 3, then we can deal with it today. Is it suitable, the time suitable to all parties?
Yes, it's good.
If anything goes wrong, or if we shed into darkness and I cannot access my laptop, well then the picture will change. As it did on Tuesday. Okay. Then we'll resume at quarter to 3. If there's anything that changes, I will inform either warrant officers or Pinard to inform you. We'll out for the first. I'm just deciding if I should deal with the law or deal with the facts first. I think I'll follow the facts and then the law. Thank you. On resumption then of RC 446 of 2020, the court will proceed with its ruling on the application for recusal of the presiding officer by Advocate Hodes in respect of accused number 1, Mr. Malema, and by Advocate Matthews in respect of accused 2, Mr. Snyman. The application is brought on the 2nd of February 2023 for the recusal of the presiding officer based on the following averments. I'm of the view that I will deal with the grounds, factual grounds raised by the defense, or let me say by the applicants firstly, and at the same time respond to each of the grounds until I reach the law and my ruling. Okay. I will start off with replying to what was stated in paragraph 10 in as far as it relates to Colonel Mngwadleka. It is alleged that the court informed the witness, I assume on 28 January 2023, according to the applicants, that it had no further questions and had excused the witness. This, however, is not a true reflection. On entering the court, I was faced with a witness in the stand, clearly one I did not even recognize. The witness in court present, I had to try and fathom why he was present and at what purpose. When I was informed that it's the witness that was to be recalled for questions by court. The court had on the last adjournment or the last day when we had proceeded with this trial clearly expressed the court will notify the state as well as the defense well in advance should that witness be recalled, and I placed that on record clearly. Therefore, I was shocked to find the witness present. I had not requested his presence. The purpose of saying I will inform all parties is so that all parties may be ready with regards to the ballistic evidence. I had not done so, was not at my request. I have nothing further to say as far as pertains to paragraph 10. The court, it's further stated that the court informed the witness it has no questions for the witness and then excused the witness. This again is clearly not a true reflection. The court reiterated on record that it is not proceeding with questions by court, it was not at the request of the court that his presence be secured. Then with reference to paragraphs 12, 13 and 14, the witness indeed confirmed he could not identify anyone. This is an objective fact established by court. I heard Advocate Matthews' argument that the defense concluded, I highlight, and I should not say defense, that the applicant concluded it can only be intended to implicate accused too. However, if memory serves me well, the video does not even depict a face. Therefore, the conclusion drawn by the applicant in this regard has no substance. And correctly, per paragraph 15, the court confirmed that the third clip was not that of the company in question. With regards to paragraph 16, I have already replied to the submissions by the applicants in that respect. With regards to paragraph 18 being the evidence of Mr. Ashley Singh, the court established from this witness that the laptop in question was stolen and that it had been verified by using the serial number. Once again, this is an objective fact. And that the hard drive was still in the possession of the company. Again, I state emphatically, it is an objective fact. It has no bias on the state or the defense. It's merely a fact. With all due respect, I think the applicants may have the facts a little muddled. Indeed, asking the witness if he is still employed at Gear Company and whether the court case has impacted on their business is once again an objective fact. The witness then stated he would rather not be in court, at which point the court proceeded to ask why, and he had given his explanation, which was accepted by the court, saying, I fully understand. That the witness, the company and Mr. Malema share a good relationship, well, it is also an objective fact. It does not indicate any bias, it doesn't indicate any prejudice on the side of the applicants. It also doesn't bolster the case of the state. It should be noted that the court did not ask if this witness was the first to this witness, as it stated in this paragraph, was the first time that this specific video footage was requested from the company. The court indeed asked, was it the first time they had received a request for video footage, to which he had replied yes. The court did not ask, was this a request for this video, the first request. Therefore, prior and after, was it their first request? He had confirmed it was. Therefore, with regards to any other parties prior or after as stated, the witness had confirmed. However, the court did not ask with regards to the specific video footage. That I want to make clear. The fact that he could not identify any person due to unclear footage is an objective fact. The answer or the fact on record doesn't further the state's case. It favors that of the applicants. I see no bias in asking that. The court has a duty to obtain objective facts, not draw subjective conclusions. The witness agreed that he had felt awkward, and based on that, the court understood his explanation based on his own statement of, I would rather not be here, and based on that statement, the court inquired why. In this sequence is what transpired in court, not how it was stated in paragraph 20 and 21. I assume the paragraphs were maybe just in the incorrect sequence. The court asking what prompted him to seek legal advice is indeed the case, but prior to asking him what prompted him to seek legal advice, the court had assured him there is no problem, it is his right to ask or seek legal advice, and then asked him if there was anything specific that had prompted him to seek legal advice. Nothing more and nothing less. It's an objective fact. His answer was left there. It wasn't pursued by court. In response to paragraph 24, 25 up to paragraph 39, I'll comment as follows. The court, I confirm that the witness testified he did not know who was on stage all the time, that people changed, etc. This is not a leading question. It's not implicating any person. It is once again an objective fact. The court asked the witness to describe the clothing of persons depicted on the video, the real evidence which was presented in court, and this he had done. It is indeed real evidence which is now placed on record. Each person's clothing was described and placed on record. There was no reference of identifying any person as depicted on the video. Stating the clothing of persons depicted on the video, which everyone can see, can never induce bias on any aspect with regards to the defense. The person wearing a red long sleeve button shirt with a collar was not identified as any person. He was not referred to by any name by court, and neither was the witness asked by court to do so. Identification was never asked by court. It is a misconception and an untruthful statement. The witness, in fact, merely described the movements and attire of parties on stage as depicted in the video, which was ruled admissible. Asking if the person was holding any object in his hand, it's not a leading question. The court is entitled to ask that question. His response was yes, but he is unable to say what type of object it was. That is an objective fact. It was left there. It was not pursued any further by court. As I've said, again, this is an objective fact. It was not taken further. It was not pursued by court. It was facts noted by court. Once again, nothing more, nothing less. With regards to paragraph 31, on that one, I do not deem it necessary to reply to the outburst in court, as it is of no consequence or significance or has any bearing on the outcome of the finding of this court today. I do not deem it necessary to dwell on that aspect. I say that for the reason and that it does not affect the ruling today, more so in the light that most of the questions, if not all, and answers noted by the respondent or the court is indeed answers that favored the applicants in this application today. With regards to paragraph 33, the court did not finalize questions by court at the time adjournment was requested. It is further incorrect to state the court or the respondent had finalized her questions and on resumption continued to ask questions. In fact, on entering court, I was informed by the applicants that they have discussed the matter and that the court should continue to finalize questions by court and thereby possibly the applicant's questions deriving from the court's questions in order to excuse the witness and finalize his evidence. That is what transpired in court yesterday. I'm still dealing with the paragraphs as mentioned and responding to it. I'm not going to repeat it was read into the record. I will refer to the paragraphs as I've been doing. Further, asking the witness, and that would still mean Mr. Singh, what his job, or Mr. Singh, the last witness, Mr. Nkwacha. Assist me, please.
Quata. It's Quata.
Quata. Thank you. What his job description entails at Gear House, and whether he had checked the equipment on the said day, and whether any problems were reported to him. The answers are objective facts. This is based on his position, as he identified himself in court as the senior AV technician. To even allege that this evidence favors the state baffles the mind. With regards to the second applicant, again referring to paragraph 6, and based on the argument by Advocate Matthews that the respondent was using this witness to attempt to identify applicant number 2 as being the person and one on the video, the only reply to this would be, it also baffles the mind, as the video does not show faces and merely a glimpse of the back of a male person. Once again, such evidence does not favor the state in any manner, neither does it bolster the state's case. I would say the opposite may be a more accurate assessment. The court now refers to the matter of Pumlani Mkolo and the state, delivered on 28 April 2022 by the Honorable Judge Stretch, sitting in Bishu, case number CC 40 of 21 Eastern Cape Division, Makanda. It's described that the doctrine of recusal has its origin in the rules of natural justice, which requires that a person or an accused should have a fair trial. This common law position has since been entrenched in the Constitution of the Republic of South Africa. Especially I refer to Section 34 of the Constitution, which affords everyone in this country the right to have any dispute that can be resolved by the application of law to be decided in a fair public hearing before a court. Section 35 is similar in that it guarantees a fair trial for persons or accused of criminal conduct. Section 165, subsection 2 of the Constitution requires courts to apply the law impartially and without fear, favor, or prejudice. The oath of office prescribed by Schedule 2 of the Constitution requires a presiding officer to swear that he or she will uphold and protect the Constitution and will administer justice to all persons alike without fear, favor, or prejudice. Further, Article 13 of the Code of Judicial Conduct states that a presiding officer must recuse him or herself if there is a real or reasonably perceived conflict of interest, or if there is a reasonable suspicion of bias, if it is based on objective facts. The Constitutional Court has summarized guidelines for the recusal of judicial officers. To mention but one is it must be assumed that a judicial officer can disabuse their minds of any irrelevant personal beliefs or predispositions. They should further keep in mind that they have a duty to sit in any case in which they are not obliged to recuse themselves. It must be considered that an impartial presiding officer is a prerequisite for a fair trial, and a judicial officer should not hesitate to recuse herself or himself if there are reasonable grounds on the part of the litigant that the judicial officer, for whatever reasons, was not or will not be impartial. Further, in State v. Legransi and others, 2009, 1 SACR 125, Supreme Court of Appeal decision by Colopin J, identified 3 core principles They also refer to State versus Duma and others. It is an unreported matter, GP case number A423/2015, delivered 12 April 2017 at paragraph 15. When addressing the issue of the impartiality of judicial officers, there is a presumption in our law against partiality of a judicial officer. This is largely based on the recognition that legal training and experience prepares the judicial officer to determine whether the truth may lie in the face of contradictory evidence, that the presumption of impartiality is not easily dislodged, cogent, and convincing evidence is necessary in order to do so, that fairness requires the judicial officer to be actively involved in the management of the trial, to control proceedings and to ensure the proper utilization of resources. It goes without saying that this sometimes involves assertiveness and the adopting of robust stances. At the end of the day, the vital ingredient of a fair trial is that justice must be done and be seen to be done. It should further be noted that applications of this nature involves a value judgment of the court applying prevailing morality and common sense. I refer to Take and Save Trading CC and others versus Standard Bank of South Africa Limited, 2004, 4SA1, Supreme Court of Appeal, where Harmse J.A. stated that a judicial officer is not simply a silent umpire. Fairness of court proceedings requires of the trier to be actively involved in the management of the trial, to control the proceedings, and to ensure that public and private resources are not wasted. Remarkably, in the course of dismissing a recusal application in Bennett and another versus the State, 2021, 2 SA 439 G to J, Spills J remarked that more and more of these applications were being brought, be it as strategic or tactical tools. The recusal of a presiding officer should not become standard equipment in a litigant's arsenal, but should be exercised for its true intended objective, namely to secure a fair trial in the interest of justice, in order to maintain both the integrity of courts and the position they ought to hold in their minds of the people whom they serve. Ongoing, unfounded aspirations cast on judicial officers could bring about a loss of faith in the judiciary and bring it into disrepute. Judicial officers must apply an objective standard and measure the facts against that standard. In Shackle, 2001, 2 SACR 185 SCA decision at 19 to 25, the Supreme Court of Appeal articulated the test for reasonable apprehension of bias as follows. The apprehension of bias must be reasonable, held by reasonable and right-minded persons, applying themselves to the question and obtaining thereon the required information. The test that would an informed person viewing the matter realistically and practically and having thought the matter through conclude. Therefore, it can safely be accepted that this court knows that an accused person is innocent until proven guilty, no matter what the charge sheet may allege, and no matter what witnesses have said or are about to say. This court is alive to the process that is to be followed, and that the prosecution carries an onus to prove the guilt of persons it accuses beyond a reasonable doubt. Whatever the position may be, it can never reasonably be suggested that because this court utilized its right to ask questions from witnesses with the objective facts in mind that it has trampled on the presumption of innocence, it can also hardly be suggested that a reasonable, objective, informed person in the position of the applicants would reasonably perceive bias upon hearing questions by court conducted in accordance with procedure, which questions is not limited to evidence in chief or limited to what is emanating from cross-examination, but which aim is to obtain information and objective facts. Nothing more and nothing less. This court is alive to the process that the prosecution carries this onus to prove the guilt. Having applied my mind to the applicant's request for my recusal and that proceedings should start de novo before another magistrate and or alternative relief, I wish to thank the applicants, that is Advocate Odes, Advocate Matthews, for well-drafted applications, for providing the court with extremely relevant case law. It is much appreciated. I have also considered the argument by Advocate Caesar and the state's stance of opposing the said application. I can assure you that my finding today is void of any emotional sentiments as far as it pertains to the application, and it is not seen as a personal attack on this court in any manner. The court has indeed applied its mind and excluded any or all subjective interpretation in the law of judicial recusal. Therefore, in my view, all that was established by this court during questions by court is indeed... Just a minute, my eyes here is not looking. I'll start again, my eyesight is not that good. Therefore, in my view, all that was established by this court during the questioning by court was indeed a process in which the court may clarify issues and obtain objective facts. That is what this court established. Applicant 1 and 2, you may stand up, please. For the reasons I have mentioned, and I have answered all your concerns in all the paragraphs cited on the application. I've given reasons for it, and therefore I find that the presumed bias you may feel is unfounded, and the application for the recusal of myself in this matter is refused.
As the court please.
Thank you. You may be seated. Thank you. Advocate Odes, may I inquire at this stage if you want to take instructions as to special review?
No. We're ready to proceed, Your Worship.
No, remember there is still...
Yes, Your Worship, I had instructions in anticipation. I can make it known without everything I was instructed. If the application is refused to proceed,
I wanted to indicate clearly that should you wish to take it on review for the High Court to decide, I am willing to follow that process and to accommodate.
My instructions are to the contrary. I have no doubt about that. The accused will confirm. Yes, we confirm. None was advised in advance.
Okay, definitely not going to proceed today.